Good afternoon, Your Honor. Daniel McGrew.
All right. Mr. McGrew, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor, and or felony, punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself in this. You have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If, for whatever reason, during any point in this proceeding, you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
This guy spent New Year's Eve blowing up his ex-wife's phone, and now he's in court calling it holiday nostalgia. He's trying to talk smooth, like he's closing a major deal at a car dealership, while the woman he's accused of harassing looks terrified on Zoom. He really thought being a top salesman was going to save him from a protective order violation. But that false confidence drops real quick when the judge starts asking actual questions. Holiday feelings do not cancel out court orders. What do you guys think? Was this harmless emotion or straight up harassment? Let's dive in.
And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or a
You wish to have a preliminary examination?
preliminary examination. Yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals for the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern of the court. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that you can sort of reconcile both of those things as whether or not discovery is complete, the defendant's prepared to move forward, and if he ever intends to file a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. McGrew, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, We will hear the motion the motion will be heard on date of exam.
Thank you, Your
Go
Honor.
with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
This guy is the ultimate textbook example of why you never represent yourself in court. He honestly thinks he can outsmart the judge, flashing that classic, entitled sovereign citizen attitude, acting superior to everyone in the room. And what is the case for? Assaulting a police officer! On top of that, he lost custody of his child over this. That is a massive, life-altering allegation. Yet he is acting like he's just strolling through a park. You can literally see Judge Simpson's patience running out. And honestly, everyone watching at home is probably shaking their heads at his complete delusion. Representing yourself never ends well. It only digs your grave deeper. The next court hearing drops next month, and it is going to be wild. If you enjoyed this breakdown, make sure to hit that like and subscribe button. It genuinely helps out the channel a ton. Thank you so much for watching, and as always, take care.